Hello, my name is Muhammad Alam, and as you know, I am a senior lawyer and owner of this law firm, Alam Law. Your lawyer in your court case that we have been handling for many months and years. Today, I'm going to talk about your upcoming pre-trial. I'm going to also talk about what does it mean, what to expect, and what can come out of this pre-trial meeting. So first of all, I will talk to you what is pre-trial. A pre-trial is an opportunity where parties get together in front of a judge and get the judge's opinion about your case. Not only about what your case has a value, but also whether or not you have a case and the merits of your case, whether or not you will win on liability or lose on liability. Let's take an example. You have a slip and fall accident, and as a result you suffered injuries. There will be an issue that will be decided by the court whether or not the other party, the occupiers or the place where you fell, if they were negligent, and if the court finds that entity or that person was not negligent, then you may not be able to win and obtain any judgment. So that's called liability. But liability in majority of the case will not be at dispute because cases which has a significant liability issue are generally decided or are very early on. But cases which comes to pre-trial means that your lawyer or team of lawyers believe that your case has merit to fight and believe that if a case is not decided or settled at pre-trial, this case has potential to go for a trial. This pre-trial is, as I said, is an option that is given to the litigant, both parties and their lawyer, in front of a judge, where the judge is going to give his or her opinion. At pre-trial, judge will not make a decision. Judge will not even enforce his opinion on the parties. But his opinion matters because these are the judges who have a lot of experience in cases like yours. And when they give an opinion about your case, about merits of the case, whether or not you will be able to win or lose, their opinion generally being respected by the parties and their lawyers. So moving forward, what this pre-trial is almost the last stage of your litigation case or your court case. After pre-trial, if it's failed, the next step is that your matter will go to a trial in front of a judge or jury. But let's only restrict our discussion for today purposes to the focus on pre-trial. Now, the pre-trial, as I mentioned earlier, various judges have different style to conduct a pre-trial. Some judges like to speak in front of clients. So in our case, you were the client. The judge would like to speak to you directly with me, sometime in front of the insurance company's lawyer and insurance company's adjuster. Some judges only want to speak to lawyers only. So if pre-trial is being held in an in-person setting, the judge will take both lawyers to his or her chamber. That is one option. Sometimes judges want to conduct pre-trial within the courtroom. In situation where a pre-trial is being conducted virtually, judge has or the registrar of the court will have an option that they can put you into a private room and take both lawyers into the judge virtual room and have a discussion. So we would not know who will be the judge or pre-trial judge and what his or her style is. But you have to be ready for all these options. So even if you're not involved, but you have to be there, and your attendance is mandatory, required by law, that you have to be there. If a judge is somebody who only wants to speak to the lawyer, then lawyer will come back to your room and speak to you about what the judge wanted to convey the message, what is his or her opinion, and then you and I, in our private virtual room, will consider what is being recommended by the judge. It could be few things. Either judge believe that your case is has a lot of challenges, and the judge will outline what he thinks and why he thinks, and those opinion will be will be presented to you by me in a private virtual room, and you and I can discuss whether or not we should listen to the judge advice or should we ignore the judge advice and move forward this case to a trial. Judges in pretrial also, so pretrial will have maybe two part. Generally it lasts 1.5 hours to 2 hours. So first hour, the judge will try to see if a resolution is possible, which means that whether or not parties are able to settle this file at pretrial, the judge will go to other room, in insurance room or other parties' room, and try to find out from their lawyer and the defendant whether or not they have money to offer, what money they like to offer and settle, and the judge will come back to our room and provide that information. Judge will also give you opinion whether or not he thinks the offer is made is reasonable or it's not reasonable. So that will be the first part, and there could be back and forth. Generally it can take 45 minutes to an hour. And after all these efforts made to see if this case can be resolved, and if the judge believes that this case cannot be settled for various reasons, the defendant is not willing to pay or not willing to pay enough that you deserve, and you and your lawyer decide that we will reject the offer and we want to move this case further towards trial. At that point, the judge will do something called trial management, which essentially means the judge will now focus his or her discussion with both lawyers, try to find out who will be the witnesses, how many days trial will last, many other things that will be discussed with respect to trial, who will be expert opinion, who will be giving expert opinion, which doctor will be testifying as a treating physician, who will be your lay witnesses, which means your friends and family member if you want to bring them as a witness. So those discussion, generally you're not involved as a client in trial management portion, but you may still be available in the virtual private room. So just in case if I need to speak to you. So throughout this pre-trial, you should be available. My office will send you the Zoom link if it is conducted virtually. And if it's in person, then you will also get the information either via email. Kindly make sure that once you get the letter about your pre-trial, you diarize it, and you must ensure that you have allocated that morning or afternoon exclusively for attending pre-trial. Do not make any other commitments. In terms of how you have to present yourself at pre-trial, few tips. Number one, you have to dress appropriately. Even a casual dress should be even fine, but it should be, you should not be wearing hoodie or cap. You should not be drinking or eating or smoking while you're attending through even virtual means. And also, I will share a few other information that's by law, that you cannot record any portion of the pre-trial proceeding. It's an offense, and you can be charged if you do that. So please make sure when you're attending pre-trial, you are in a private room or in an area where only you are available and not other people are either interfering with you. When you are not speaking, try to turn off your mic or microphone, but make sure that you are in a private setting where not other people are, behind you, or just focus on the camera. At the pre-trial, also, as I said, even if you disagree with the judge's opinion, you should be very respectful, because being disrespectful to a judge will really not help your case, even if we're moving your case forward to a trial. So you have to be respectful. The judge also give very important opinion about two issues. Number one, if it's car accident case that you're going for pre-trial, there is something called threshold injuries, which means whether or not your injuries are serious and permanent. And there's, as you know from your discovery prep or mediation video, that there is a deductible of $40,000 for car accident victims. If whatever amount you were awarded by a judge or jury, $40,000 for general damages will be wiped off. But that deductible and threshold injuries for serious and permanent does not apply to any other personal injury case. So whether it's medical malpractice, whether it's any other negligence case, product liability, dog bites, slip and fall, so those threshold and the deductible on your pain and suffer does not apply for those cases. But the judge will give you a very important opinion about liability, whether or not, because liability is important. So let's say if it's a slip and fall or product liability case that you have, and the judge opinion that you will not be able to prove that the other party or defendant was negligent in maintaining their property in a reasonable fashion, or if this case is against city, then the standard is just a little bit higher in terms of negligence, which means we have to prove that the city was grossly negligent. So that's a higher threshold to prove. And if the judge's opinion based on the evidence at discovery or any other documents that was presented to the judge at pretrial brief, with the pretrial brief, and if judge opinion that you will not be able to prove negligence, then essentially the judge will say that you're going to lose this case. And this will be the best opportunity at this time that you should try to get out of this case. But those cases, when I get the opinion, I seriously take that opinion from the judge and I will convey to you. The second thing will be, in terms of settlement, many cases settle. As I say, I can safely say out of 100 cases, almost 70 cases settle at pre-trial. The remaining 30 cases can settle either before trial or from a time today until the date of trial. So I will be in touch with you. I will look forward to meeting you at the pre-trial. If you have any question or any other question related to your attendance, or if you have not received the Zoom link for your attendance, or if you're confused about in-person attendance and you do not have the proper address of the court, kindly call the office and speak to one of my assistant who can provide you all these information. And I thank you for watching this video.